everybody, this is Tracy here with another edition of A View from Tracy's Point. And we are here today to talk about one, the Michael Avenatti verdict, and then two, a superseding indictment that came down today in the Northern District of Illinois in the case with Robert Kelly, Darren McDavid, and Milton Brown. And so I had mentioned in my last video that they're going to try and do everything that they can to get anybody to flip in these cases, or to get R. Kelly to plead guilty in these cases. So it's no surprise that they are continuing to try and pile on these additional charges. And even more interesting is the fact that there was no new grand jury that adjourned or came together. I can't think of the word I'm trying to use, but there's no surprise that a new grand jury wasn't seated, that these is still information that's coming out from the May 2019 grand jury, special grand jury that they formed to get these charges. And then also remember that it doesn't take a whole lot to get a grand jury to hand down an indictment. And so this to me is just another attempt to either get him to plead guilty to something, or, to avoid having to take this thing to trial, or they're trying to get Milton Brown or either Darren McDavid to turn against R. Kelly. And, because they are I guess they would be more powerful witnesses against him in this case. So if they can get them to flip, then they'll have a stronger case against him, and then probably motivate him to go ahead and just plead out to these charges. So just a little bit on the Michael Avenatti situation, and then I'll go ahead, as I always do, and read the indictment, the new charges against him. So with the Michael Avenatti case, the jury came back after deliberations were delayed. He was found guilty. And so yesterday, I think it was, they had to stop deliberations because one of the jurors had a job interview that she had to go to, or he had to go to. So they had to delay the deliberations, but then they did come back today and find him guilty on all three charges. And so I'm just going to read a little bit from the article that appeared on the NBC News website. It says, lawyer Michael Avenatti has been found guilty on all counts of trying to extort $25 million from Nike. It says that the verdict was confirmed by the U.S. Attorney's Office in Manhattan, which brought the case. Avenatti faces a statutory maximum of 20 years in prison. The jury's decision in U.S. District Court in Manhattan came Friday after a 3-week trial for the lawyer who gained fame representing porn star Stormy Daniels in lawsuits against President Donald Trump. Jurors began deliberating on Wednesday. Avenatti was arrested in March after he and an uncharged conspirator, who we know is attorney Mark Garagos, threatened to hold a news conference to ruin Nike's reputation and to hold a Nike press conference that would essentially have destroyed their stock value. He had threatened to knock billions of dollars off of their valuation. And so there was a quote saying, "You guys know enough to know you've gotten a serious problem, and it's worth more in exposure to me to just blow the lid off this thing. A few $1 million doesn't move the needle for me." So this is what the extortion sounds like. Assistant U.S. Attorney Matthew Podolsky said after repeatedly playing Avenatti's recorded demands. And remember, I think it was Mark Garagos had agreed to allow them to record these conversations. And so they have him on, video, just basically, implicating himself in this crime. And this was also the video where he says that, in the R. Kelly case and the Trump case, that, it's 90% BS and 10% of it is factual.
I just want to share with you what's going to happen if we don't reach a resolution. As soon as this becomes public, I'm going to receive calls from all over the country, from parents and coaches and friends and all kinds of people, because this is always what happens. And they're all going to say, I've got an email or a text message or... Now, 90% of that's going to be bullshit. Because it's always bullshit, 90%. Always. Whether it's R. Kelly or Trump or the list goes on and on. But 10% of it is actually going to be true.
And so Avenatti still faces other legal hurdles, including federal charges in California for defrauding clients and absconding with payments to them that he was able to obtain, including theft from a quadriplegic man. He also faces a separate federal case in New York tied to allegations that he kept $300,000 in money from a book publisher that was supposed to be paid to Stormy Daniels. And then it goes on to talk about how he rose to popularity. In the Nike case, prosecutors said Avenatti demanded that the sportswear company pay a client of his $1.5 million in compensation. But then that guy actually testified in the case and was like, he didn't know that Avenatti was out there trying to extort money on his behalf and that he was not part of the plan. And so Avenatti allegedly had debt over $11 million at the time of the extortion scheme. He had met with Nike representatives on March 19th, claiming to represent a youth basketball coach who had information that Nike employees made illicit payments to the families of high school athletes and threatening to hold a news conference to expose the company unless it agreed to pay him and his client millions of dollars. And just to show you guys, all of this started in March of last year, so less than a year. And they brought these charges against him and they've had his trial because they had a solid case. They had a slam dunk here. Whereas in the R. Kelly case, they obviously don't have a slam dunk, or they would have, they would have tried him by now and all this be over and done with. They wouldn't keep trying to add on and add on and add on. And so Avenatti had pleaded not guilty. His lawyer said he was simply pursuing an honest negotiation with the company on behalf of a client, Gary Franklin, an amateur basketball coach who wanted Nike to clean up its act. During closing arguments, one of the attorneys, Howard Schreback, urged jurors to disregard the California attorney's four-letter words. This was exactly what the clients wanted. He acted in good faith. Schrebnick said not guilty. And so throughout the recording, Michael Avenatti is, he's cursing and carrying on, trying to make himself seem like a tough guy. And so his attorneys were basically saying that the reason they're trying to say that it was extortion was because of the harsh language, but he was just trying to prove a point. But I think what got Avenatti was when he tried to ask for that $25 million. I think that's what made it extortion. He wanted money in exchange for not going public with the information. And if it was a good faith gesture, he would have went public and not requested any money. It says, well, prosecutors drilled down on Avenatti's debt and said he was looking out for his bottom line, not the client. Michael Avenatti, facing a mountain of debt, saw light at the end of the tunnel. Avenatti's former law firm office manager had testified that money was so tight that there were some employees that had been forced to leave their offices and work from home. He owed the IRS $850,000 in unpaid taxes plus interest and penalties, prosecutors said. Then just goes on and talk more about the Stormy Daniels case that is coming up. It says both cases involving Daniels in New York and the case alleging fraud in Los Angeles federal court are scheduled to go to trial in the spring. So this just goes to show, like the old folks used to say, you dig one ditch, you better dig two, because the trap you set for somebody else might be the trap you set for yourself. And so he got this whole ball rolling, piggybacking off the whole surviving R. Kelly, then got into bed with Angelo Clary and the rest of the groupies, to form this case against R. Kelly. And now he's the one that's ended up going to jail before R. Kelly has even gone to court. And a lot of people are saying that basically since Avenatti has been found guilty, he has this string of fraudulent behavior that he engages in, that, any evidence that he presented in the R. Kelly case should not be valuable or useful, that they need to toss that out, and Greenberg needs to start filing motions to have that tossed out. And speaking of Greenberg, he's actually going to be on Court TV this evening at 6 p.m. Eastern time, and I think he's going to answer questions about the case. That information was publicized on Court TV before the news rolled out about the superseding indictment, but I'm sure he knew it was coming down, so that may be why he agreed to go on Court TV. He is friends with them, and he has been on a couple of other times to talk briefly about what's going on with the case. So if you get an opportunity, make sure you tune in. If Court TV doesn't come on in your area, they do air live on their website, which is courttv.com, and that's court and then TV, so two T's in there running together. So now let's go ahead and get into this new indictment that came down. So this is a 26-page indictment, so bear with me, guys. I was actually preparing to remember I told you guys I was going to do a video on YouTube, and the YouTube video is actually something that I have been wanting to do for quite some time. And then I wrote a blog for a client about 2 weeks ago talking about YouTube and earning money on YouTube, and then just looking at conversations that's going on about how different YouTubers utilize their channel. And so I just wanted to put a video together just talking about how YouTube works, and there's different ways that people go about handling their channel. And so I am going to still work on that, but I wanted to bring this information to you guys first. And depending on how my day goes, I'll go ahead and get that video out later on this evening, or it may be tomorrow when I bring that YouTube video to you. So this was filed today, actually filed yesterday, February 13. And it's United States of America versus Robert Sylvester Kelly, also known as R. Kelly, Darrell McDavid, and Milton Brown. And so it says count 1, special May 2019 grand jury charges in or around 1998 or 1999 at Chicago in the Northern District of Illinois. Robert Sylvester Kelly, also known as R. Kelly, defendant herein, did knowingly employ, use, persuade, induce, entice, and coerce a minor, namely minor 1, to engage in explicit conduct for the purpose of producing a visual depiction of such conduct, namely video 1. And defendant knew or had reason to know that such visual depiction would be transported in interstate or foreign commerce, or mailed, or such visual depiction was actually transported in interstate or foreign commerce or mailed in violation of Title 18 United States Code Section 2251A. Count 2, the special May 2019 grand jury further charges between approximately September 26, 1998 and September 25, 1999 at Chicago in the Northern District of, okay, that got away from me while I'm trying to get back to my spot. I've already read this indictment when it first came down last year, but I'm rereading it because sometimes they will, even though they're just adding a sixth person to the indictment, they may have changed some of the wording or added some more information on the other charges. And plus, there may be somebody watching for the first time today who wasn't privy to that video that I did previously, but I will drop that video link in this video. So back to where I was at, where I lost my place. It says that Robert Sylvester Kelly, also known as R. Kelly, defendant herein did knowingly employ, use, persuade, induce, entice, and coerce a minor, namely minor 1, to engage in sexually explicit conduct for the purpose of producing a visual depiction of such conduct, namely video 2, and defendant knew or had reason to know that such visual depiction would be transported in interstate or foreign commerce or mailed, or such visual depiction was actually transported in interstate or foreign commerce or mailed in violation of Title 18, United States Section 2251. And for those who don't know, minor 1 is Rishana Landfair. So count 3, special May 2019. It's going to say that 2019 grand jury on these charges. I don't need to keep reading that. Between approximately September 26, 1998 and September 25th, 1999 at Chicago in the Northern District of Illinois, Eastern Division, Robert Sylvester Kelly, also known as R. Kelly, defendant herein, did knowingly employ, use, persuade, induce, entice, and coerce a minor, namely minor 1, to engage in sexually explicit conduct for the purpose of producing a visual depiction of such conduct, namely video 3, and defendant knew or had reason to know that such visual depiction would be transported in interstate or federal or foreign commerce or mailed, or such visual depiction was actually transported in interstate or foreign commerce in or mailed in violation of Title 18 United States Code Section 2251A. Count 4, blah, blah, blah. Robert Sylvester Kelly, also known as R. Kelly. And then it pretty much says the same thing about minor 1. So now they're alleging that there were 4 videos. So now this is video 4. And then count 5, same information. It says 1, at times material to this indictment. Defendant Robert Sylvester Kelly, also known as R. Kelly, was a resident of Chicago, Illinois, and was a Grammy Award-winning recording artist and record producer. Kelly was the president and manager of several businesses, each located in Chicago in the Northern District of Illinois, that he maintained in furtherance of his music career, including but not limited to Bass Productions Limited and RSK Enterprises, LLC, the Kelly business. B, from in and around June 1991 until in or around January 2014, Kelly and one or more of the Kelly businesses employed defendant Darryl McDavid as a business manager. McDavid was a principal at Winkler and McDavid Limited, located in Oak Park, Illinois. As a manager for Kelly, McDavid was involved in providing services to Kelly, which services were in part intended to protect Kelly's image, reputation, and assets in the face of actual and potential criminal and civil actions involving individuals who were victims of misconduct by Kelly. And so this is important because they're now trying to say that if he's found guilty, they are going to they're going to seize this Bass production, which I don't even know if it's still in operation or even have any value. So I don't know what the point of this is, but anyway, we're going to keep on reading. C, from at least approximately 1997 to at least approximately February 2019, Milton Brown, also known as June Brown, was employed by Kelly and or one or more of the Kelly businesses. D. Minor 1 met Kelly in or around 1996 or 1997 when minor 1 was approximately 12 or 13 years old. And those, we keep dropping this age down, down, down. And then minor 3 met Kelly in or around 1996 when minor 3 was approximately 15 years old. F. Minor 4 met Kelly in or around 1999 when minor 4 was approximately 16 years old. G. Minor 5 met Kelly in or around 1997 or 1998 when minor 5 was approximately 13 or 14 years old. H. Minor 6 met Kelly in or around 1997 or 1998 when minor 6 was approximately 14 or 15 years old. And please take note that we don't have a minor 2 anymore. So now I got to go back and look at my notes because I just realized this, that they don't have minor 2 on here to see who we thought minor 2 was. But anyway, continuing on, it says I, Kelly, was born in 1967. J, Kelly engaged in contact and acts as those terms are defined in Title 18 United States Code Section 2246 with minor 1, minor 3, minor 4, minor 5, and minor 6 when they were each under the age of 18. K, between, in, or around 1998 and in around 2002, Kelly recorded himself on video engaging in contact and acts with minors, including minor 1, minor 4, and minor 5. L, video 1, video 2, video 3, and video 4 depict Kelly engaged in contact and acts with minor 1 when minor 1 was under the age of 18. M, in approximately April 2000, the Illinois Department of Children and Family Services began to investigate whether Kelly was abusing minor 1. N, on or about June 5th, 2002, a grand jury of the Circuit Court of Cook County, Illinois, returned an indictment charging Kelly in the case of People of the State of Illinois versus Robert Kelly, 02CR 14952 Cook County case, with 21 counts of child pornography relating to video 1 and minor 1. The case was tried to a jury beginning on May 20th, 2008, and on June 13, 2008, Kelly was acquitted of those charges. 2. Beginning in approximately 2000 and continuing to the date of the return of the superseding indictment at Chicago in the Northern District of Illinois and elsewhere, Robert Sylvester Kelly, also known as R. Kelly, and Darrell McDavid, defendants herein, did knowingly conspire with each other, individual A and others known and unknown to the grand jurors, to commit an offense against the United States, namely, to knowingly alter, destroy, mutilate, conceal, cover up, falsify, and make a false entry in any record, document, and tangible object with the intent to impede, obstruct, and influence the investigation and proper administration of any matter within the jurisdiction of any department or agency of the United States, and in relation to and contemplation of such matter or case in violation of Title 18 United States Code Section 1519. Number 3, it was part of the conspiracy that Kelly, McDavid, and others knew of Kelly's contact and acts with minors and knew that Kelly recorded himself engaging in contact and acts with minors on videotape. 4, it was further part of the conspiracy that in approximately 2001, Kelly and McDavid learned that multiple videos, including but not limited to video 1, video 2, video 3, and video 4, depicting Kelly engaged in contact and acts with minors were missing from Kelly's collection of such videos. 5, it was further part of the conspiracy that in order to conceal and cover up the existence of videos from investigators, Kelly, McDavid, and others agreed to collect the missing videos that depicted Kelly engaged in contact and acts with minors. And you guys remember, this is the whole thing, I believe, with Lisa Van Allen, and maybe Lisa Van Allen was number 2 on this indictment that I need to go back and look at. But remember, they tried to extort him with these tapes. She stole the tapes, and then they tried to sell the tapes back to him or something going on. But that's what they're talking about. Number 6, it was further part of the conspiracy that Kelly, McDavid, and others agreed to pay money and cause money to be paid on Kelly's behalf to victims, witnesses, and others to ensure that they would not cooperate with law enforcement and would conceal and cover up evidence, including videos relating to Kelly's contact and acts with minors, such as the following. A, between approximately 2001 and approximately 2009, Kelly, McDavid, individual A, and others caused individual B to be paid hundreds of thousands of dollars for obtaining and returning multiple videos that they know depicted Kelly engaged in contact and acts with a minor. So this is definitely with Lisa Van Allen, and then the guy that she was dating, remember, he was arrested or something. So they're individual A and individual B. And in approximately early 2007, Kelly and McDavid agreed to pay individual D approximately $250,000 to return a videotape that they knew depicted Kelly engaged in contact and acts with minor 1 and individual D. So is individual D Lisa Van Allen? I'm confused. Now I'm going to have to go back to that story, because I thought it was just Lisa and the guy that she was dating, and then they mentioned the Pryor guy, the Damon Pryor, I think his name is. But I thought Lisa was the one that was supposedly in the video. Y'all let me know in the comments, because I know some of y'all know more than I do and remember better than I do that whole situation. It says in approximately 2007, Kelly and McDavid paid individual C and individual D each approximately $100,000 in exchange for their efforts to return to Kelly videotapes that they knew depicted Kelly engaged in contact and acts with minor 1 and individual D. On or about April 17, 2007, Kelly and McDavid caused one of Kelly's businesses, Bass Productions Limited, to issue a check in the amount of $200,000 to Brown. Right, that was the, I need to get these names. To Brown, June Brown, who cashed the check that same day, which Kelly, McDavid, and Brown intended to use to pay individual C and individual D for their efforts to return to Kelly videotapes that they knew depicted Kelly engaged in contact and acts with minor 1 and individual D. As a condition of being paid money for returning videotapes that depicted Kelly engaged in contact and acts with minors, Kelly and McDavid directed individual B, individual C, and individual D to take polygraph examinations regarding whether they had returned all copies of such tapes. F, in approximately June 2008, after learning that individual B planned to announce at a press conference that he had recovered videos depicting Kelly engaged in contact and acts with minors, McDavid and others paid individual B approximately $170,000 to cancel the press conference. G, in approximately 2014 and 2015, Kelly paid McDavid to ensure that McDavid would continue to conceal and cover up evidence, including but not limited to video 2, video 3, and video 4, relating to Kelly's contact and acts with minors. And remember, McDavid has said all along that this $170,000 had nothing to do with any of this that they're alleging. And so I'll have to go back once again and find that what the $170,000 was for. 7, It was further part of the conspiracy that Kelly, McDavid, and others agreed to intimidate, threaten, pressure, persuade, and attempt to persuade other individuals, including but not limited to minor one, minor one's parents, individual D, and minor 5, to falsify and make false entry in a record, document, and tangible object related to Kelly's contact and acts with minors, such as the following. A, in approximately December 2000, pursuant to instructions that minor A received from Kelly, minor one received from Kelly, minor one falsified and caused a false entry to be made in a police report when minor one denied to law enforcement officers that Kelly engaged in a relationship with minor one. B, in approximately May 2002, McDavid instructed minor one's father to provide knowingly false testimony to the Cook County grand jury investigating Kelly's relationship with minor one. McDavid instructed minor one's father to deny that video one depicted minor one engaged in sexual acts with Kelly when McDavid knew that video one did depict minor one engaged in acts with Kelly. As instructed, minor one's father falsely denied to the grand jurors that video one depicted Kelly and minor one, thus creating a false record and a false entry in a record, document, and tangible object. C, in approximately May 2002, Kelly persuaded minor one to provide knowingly false testimony to the Cook County grand jury investigating Kelly's relationship with minor one. Minor one falsely denied to the grand jurors that Kelly engaged in a relationship with minor one and that minor one was not depicted on video one, thus creating a false record and a false entry in a record, document, and tangible object. And then it says D, in approximately May 2002, Kelly attempted to persuade minor 5 to provide knowingly false testimony to the Cook County grand jury investigating Kelly's relationship with minor 1, in that Kelly instructed minor 5 to testify falsely that she did not recognize minor 1 or video 1. On or about July 26, 2007, Kelly and McDavid directed individual D to falsely deny that individual D and Kelly engaged in acts together with minor 1 when Kelly and McDavid knew that Kelly had engaged in acts together with minor 1 and individual D as Kelly and McDavid intended. A false record, document, and tangible object was prepared based upon individual D's false statements. Then number 8, it was further part of the conspiracy that Kelly, McDavid, and others agreed to intimidate, threaten, pressure, persuade, and provide benefits and money to victims' family members, witnesses, and others to ensure that would destroy, conceal, cover up, falsify, and make a false entry in a record, document, and tangible object, and continue to abide by previous false statements and entries in such items relating to Kelly's contact and acts with minors, such as the following. A, in approximately January and February 2002, Kelly and McDavid caused minor 1 and minor 1's parents to travel to foreign countries to make them unavailable to law enforcement investigating minor 1's relationship with Kelly and video 1. B, from at least approximately 2000 to approximately 2015, Kelly and McDavid made payments, gifts for minor 1 and minor 1's parents with the intent to persuade and induce minor 1 and minor 1's parents to conceal, cover up, falsify, and make a false entry in any record, document, and tangible object about Kelly's relationship with minor 1, and to continue to abide by previous false statements and entries in such items, including the existence of multiple videos depicting Kelly in engaging in contact and acts with minor one. Between approximately January 2014 and approximately October 2015, Kelly caused monthly payments to be made to minor one via the Kelly businesses, many of which contained settlement in the transaction line or something similar. Kelly made these payments to ensure that minor one continued to abide by her prior false statements regarding Kelly's relationship with minor one and to ensure that minor one continued to conceal and cover up the existence of multiple videos depicting Kelly engaged in contact and sexual acts with minor one. Now, who would be so stupid as to do just to write settlement in the memo if you're paying somebody off? Like, that makes absolutely no sense. But anyway, D, in approximately 2014 and 2015, McDavid received payments from Kelly relating to services he provided to conceal and cover up evidence, including but not limited to video 2, video 3, and video 4, and to continue to conceal and cover up such evidence of Kelly's contact and acts with minors that he provided to protect Kelly's image, reputation, and assets in the face of actual and potential criminal and civil actions by individuals whose victims of misconduct by Kelly, including services that McDavid provided to falsify and create a false entry in a record, document, and tangible object. 9, it was further part of the conspiracy that Kelly used physical abuse, violence, threats of violence, blackmail, and other controlling behaviors against victims so that Kelly could maintain control over them, prevent them from providing evidence to law enforcement, and persuade them to continue to abide by prior false statements relating to Kelly's contact and acts with minors and videos of such conduct. 10, it was further part of the conspiracy that Kelly, McDavid, Individual A, and others concealed and hid and caused to be concealed and hidden the existence of and acts done in furtherance of the conspiracy. Overt acts. Number 11, in furtherance of the conspiracy and to accomplish the objectives of the conspiracy, defendants committed one or more overt acts in the Northern District of Illinois, Eastern Division, and elsewhere, which overt acts included but were not limited to the following. A, on or about August 21st, 2001, Individual A, acting as an agent for Kelly and McDavid, entered into a contract with Individual B to recover and return videotapes and depicted Kelly engaged in contact and acts with minors in exchange for $100,000 plus no more than $40,000 in expenses. The contract required Individual B to deliver the tapes to Individual A by Thursday, August 23rd, 2001, in order to receive payment. B, on or about approximately April 17, 2007 and April 20th, 2007, McDavid, on Kelly's behalf, received from Individual C and Individual D videotapes that McDavid and Kelly knew depicted Kelly engaged in contact and acts with minor one and Individual D. So are we going to say that Individual D is Lisa Van Allen, and then individuals B and C are Damon Pryor, and then the guy that Lisa Van Allen was dating, and I'll look up what his name was because his name is escaping me, but I think he ended up going to jail and something, and she left R. Kelly to go be with this guy, and then the guy ended up going to jail, and then R. Kelly was dumb enough to take her back. I don't know why. And I think his compassion for these low-down, low-trodden women that he has gotten caught up with is, everything stems back to the parents. And I think it has something to do with whatever his relationship was with his mother. Seeing his, it's no secret that all of them have different fathers. And so maybe seeing his mother interact with men so that she could pay her bills or, whatever was going on. whatever his relationship was with his mother, I think is what leads him to be so kind and some compassionate with these low-level women, because we already see that there were other women who he treated really good, that are not coming after him, that are not, being a part of this whole conspiracy that's going on. And so if he gets out of this, when he gets out of this, I hope he learns a valuable lesson in the type of caliber of women he needs to be dealing with. So C, in approximately March and April 2007, at the direction of McDavid on Kelly's behalf, individual C and individual D took polygraph examinations regarding the videotapes that individual C and individual D had returned depicting Kelly engaged in contact and acts with minor 1 and individual D, including whether there were additional copies of the videotapes. D, in approximately September 2008, Kelly calls Bass Productions Limited check signed by McDavid to be issued to minor 1's father, payable in the amount of $30,000. On or about June 30th, 2009, Kelly and McDavid caused a wire payment to be made from a Bass Production Limited bank account to pay individual B to settle a lawsuit that individual B had filed for payment for recovering and returning videotapes that depicted Kelly engaged in contact and acts with the minors. So you mean tell me that you that stole somebody's property, blackmailing them to return the property, and then when they refuse to pay you, you filed a lawsuit against them? Like, what kind of nonsense is this? And then also, I'm just thinking, like, the way my mind works. If I'm trying to pay you not to tell on me, ain't gonna be no checks, ain't gonna be no wire transfers. I'm gonna get some cash. I'm gonna ask so-and-so over here who got money to give me this cash, and then I'm going to give you the cash, and then I'm going to give them back their cash. Like, ain't gonna be no paper trail for none of this going on. These people are crazy. Then F, in approximately August 2013, Kelly calls Bass Productions Limited to transfer title of a GMC Yukon Denali to minor 1. In approximately September 2014, Kelly calls a wire transfer in the amount of $80,000 to be paid to McDavid through his firm Winkler and McDavid Limited. And then the other thing, they're saying that he was paying off Rishana and her family. I'm thinking, as big as this case was, they sure wasn't asking for a lot of money. Now, were they? Like, that's the other crazy part. Like, we ain't gonna be giving me no used cars. We ain't gonna be slipping me no $1,500 to pay my rent. I would have gotten, like, every time he got paid, I would have got paid. Every time a royalty check rolled in, I would have got some of that money from those royalty checks. And so it's like, none of this is just really adding up in my mind, but then that's just how my mind works, and the mind of the criminals that I know personally. Like, none of this would have took place. What else does it say? In approximately October 2014, Kelly calls RSK Enterprise LLC check to be issued to minor 1, payable in the amount of $1,150 for the notation personal RK in the memo line. In approximately October 2015, Kelly calls the wire payment to be made from RSK Enterprises LLC to minor 1, payable in the amount of $1,150 for the notation settlement payment, although the payment was not made pursuant to a settlement with Kelly. Okay, so was she sued by somebody else? I mean, I'm just not understanding. I'm really not. J, in approximately December 2015, Kelly calls the wire payment in the amount of $100,000 to be made from RSK Enterprises LLC to agents of McDavid on McDavid's behalf, all in violation of Title 18 United States Code Section 371. Now, the problem I think that they're going to have when they get to court in dealing with the payments to Daryl McDavid is, if this person was hired to represent you, then you owe them money for the services they provide, right? And so to me, this is no different than if you hire Steve Greenberg to represent you in this case against you, or to represent you in any other case. How are you then going to come back and say that the services he provided to you were somehow a part of this conspiracy and these alleged crimes? And so as Daryl McDavid, if he says, oh, I need you to go deal with this situation, that was Daryl McDavid's job to go and deal with that situation. And, people sign non-disclosures every day. People pay settlements every day. Like, that's a big part of the entertainment industry, is that people don't have time to be bothered with every person that comes along and says that they're going to sue you for something. And so you send your people in, like, ask these people what they want, give them what they want, to have them sign this non-disclosure and get on down the road. And so I don't see how Daryl McDavid, can be implicated in doing his job. I don't get that part. I don't know. So moving on to count 6. The special day 2019 grand jury further charges paragraphs 1, 3, 4, 5, 6, 7, E and 8 of count 5 are incorporated here. 2, beginning in or around August 2001 and continuing in or around April 2007 at Chicago in the Northern District of Illinois, Eastern Division, and elsewhere. Let's see. Robert Sylvester Kelly, also known as R. Kelly, Daryl McDavid, and Milton Brown, also known as June Brown, defendants herein, blah, 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 blah. Grand jurors to receive child pornography, blah, blah, blah. Okay, so I read all that from the first part, in violation of Title 18 U.S. Codes. Okay, count 7, the special day in May 2019, in or around August 2001 at Chicago in the Northern District of Illinois, Eastern District, and elsewhere. Robert Sylvester Kelly, also known as R. Kelly, and Daryl McDavid, defendants herein did knowingly receive pornography as defined in Title 18 United States Code sections 2256 8A, namely video 2 and video 3, that has been mailed and shipped and transported in interstate and foreign commerce by any means in violation of Title 18 United States Code sections 2252 A2 and 2. Count 8, the special May 2019 jury, from or about April 17, 2007 to on or about April 20th, 2007 at Chicago in the Northern District of Illinois, Eastern Division, and elsewhere. Robert Sylvester Kelly, also known as R. Kelly, and Daryl McDavid, defendants herein did knowingly receive pornography as defined in Title 18 United States Code section 2256, namely video 4, that has been mailed and shipped and transported in interstate and foreign commerce by any means. So they're not really explaining what they mean by shipped or transported. I guess they're saying that they received the videos, and so they're charging them not only for the conspiracy to get the videos back, but then now they're charging them for actually receiving the videos. So beginning from approximately 1997 and continuing to approximately 2001 at Chicago in the Northern District of Illinois, Eastern Division, Robert Sylvester Kelly, also known as R. Kelly, defendants herein using the mail or any facility and means of interstate and foreign commerce did knowingly persuade, induce, entice, and coerce any individual, namely minor 1, who had not attained the age of 18 years, to engage in activity for which any person can be charged with a criminal offense, namely aggravated criminal abuse in violation of Title 720 Illinois compiled statute 5/12-16 'D, in violation of Title 18 United States Code, Section 2422B. Count 10, okay. In or around summer 1996 in Chicago, in the Northern District of Illinois, Eastern Division, and elsewhere, Robert Sylvester Kelly, also known as R. Kelly, defendant herein using the mail or any facility and means of interstate and foreign commerce did knowingly persuade, induce, entice, or coerce any individual, namely minor 3, who had not attained the age of 18 years to engage in activity for which any person can be charged with a criminal offense, namely aggravated criminal sexual abuse, in violation of Title 720, Illinois Compiled Statute, Section 5-12-16D, in violation of Title 18, United States Code, Section 2422. Count 11, the special May 2019 grand jury further charges beginning from approximately 1999 and continuing to approximately August 2000 at Chicago in the Northern District of Illinois, Eastern Division. Robert Sylvester Kelly, also known as R. Kelly, defendant herein using the mail or any facility and means of interstate and foreign commerce, did knowingly persuade, induce, entice, and coerce any individual, namely minor 4, who did not attain the age of 18 years to engage in activity for which any person can be charged with a criminal offense, namely exploitation of a child, in violation of Title 18 United States Code, Section 2251, in violation of Title 8 United States Code, Section 2422B. Count 12, the special May 2019 grand jury further charges beginning from approximately 1997 and continuing to approximately October 2001 at Chicago in the Northern District of Illinois, Eastern Division, Robert Sylvester Kelly, also known as R. Kelly, defendant herein using the mail or any facility and means of interstate and foreign commerce did knowingly persuade, induce, entice, and coerce any individual, namely minor 5, who had not attained the age of 18 years to engage in activity for which any person can be charged with a criminal offense, namely aggravated criminal abuse, in violation of Title 720, Illinois Compiled Statute, Section 512-16D, in violation of Title 18 United States Code, Section 2422. Count 13, we went through all this, beginning from approximately 1997 and continuing to approximately December 2000 at Chicago in the Northern District of Illinois, Eastern Division. Robert Sylvester Kelly, also known as R. Kelly, defendant herein using the mail or any facility and means of interstate and foreign commerce did knowingly persuade, entice, induce, and coerce any individual, namely minor 6, who had not attained the age of 18 years to engage in activity for which any person can be charged with a criminal offense, namely aggravated criminal abuse, in violation of Title 720 Illinois Compiled Statute, Section 5/12-16D, in violation of Title 18 United States Code, Section 2422B. Forfeiture allegation. Same thing about the grand jury. 1, upon conviction of an offense in violation of Title 18 United States Code, Sections 2251 and 52A, as set forth in the superseding indictment, defendants Robert Sylvester Kelly, Darrell McDavid, Milton Brown shall forfeit to the United States of America any matter which contains visual depictions described in Title 18 United States Code, Section 2252A, any property constituting and traceable to gross profits and other proceeds obtained from such offense, and any property used and intended to be used to commit and to promote the commission of such offense, and any property traceable to such property as provided by Title 18 United States Code, Section 2253. 2. Upon conviction of an offense in violation of Title 18 United States Code, Section 2422, as set forth by this superseding indictment, defendant Robert Kelly shall forfeit to the United States of America any property, real or personal, used or intended to be used to commit or to facilitate the commission of such offense, and any property, real or personal, that constitutes or derived from proceeds traceable to any such offense as provided by Title 18 United States Code, Section 2428. 3. The property to be forfeited includes but is not limited to a personal money judgment in the amount of at least approximately $1,554,748, and B, all rights, title, and interests in stock and all other ownership interests in Bass Productions Limited and Winkler and McDavid Limited in whatever form held by defendants. 4. If any other property described above as a result of any act or omission by a defendant cannot be located upon the exercise of due diligence, has been transferred or sold to or deposited with a third party, has been placed beyond the jurisdictions of the court, has been substantially diminished in value, or has been commingled with other property which cannot be divided without difficulty, the United States of America shall be entitled to forfeiture of substitute property, as provided by Title 21 United States Code, Section 853. So there you go, guys. Let me go and look up and see who I thought these people were. And also, I thought the person 2 and 3 are the same people that are on the New York indictment that they're refusing to give information on, which was supposed to be the Patrice Jones, and then the person that nobody seems to know who she is, that was allegedly flown in to do the interview. So by them eliminating number 2, y'all get where I'm going here? I had to go check and see. So Lisa Van Allen was the person we thought was minor 2. But then, as I've stated previously, I thought on the New York indictment, they said that minor number 2 and minor number 3 were also the same people that were on the Illinois indictment. And so we know that Rashana Landfair is minor number 1 and like 90% of the entire case for the Northern District of Illinois. And so if minor 2 and minor 3 are the same people on the New York indictment, then minor number 2 was not Lisa Van Allen. And then people speculated that minor number 4 was Tracy Sampson, and that minor number 5 could have been Tiffany Hawkins, I think they were saying, is who that could have been. So now we have a minor 6. So I'm not sure if Lisa Van Allen is now minor 6, or if whoever was minor number 2 is now minor number 6. But there's definitely been some shuffling of the cards going on, and this new superseding indictment does not list a minor 2. And then also, if minor 2 and minor 3 are the same people from the New York indictment, does that mean that minor 2 is going to be dropped? Because if you remember on my last video, I shared that people were thinking that the reason New York has not named minor 2 and minor 3, or Jane Doe number 2 and Jane Doe number 3, is because they haven't been fully vetted. They haven't been able to substantiate their claims and to get their evidence that they claim that they have for these two people. And so who knows, we'll have to wait and see. Northern District could have just shuffled some cards here, or they could have removed that person from the case altogether. We'll have to wait and see. And then I was going to tell you guys about, remember, I couldn't get the names straight on who these people were. So this is from the Los Angeles Times article back in 2008 when they were doing the trial. And so let me see. It says Judge Vincent Gahn admonished the witness, Lisa Van Allen, that some of her testimony could be self-incriminating, but did not specify what he was referring to. Van Allen will be the prosecution's first witness this morning, and direct examination is expected to take about 30 minutes, prosecutors said in court. And then it says Kelly's attorneys are expected to accuse her of offering to switch her testimony for a jaw-dropping price. The defense team has described it as an extortion attempt and unsuccessfully petitioned Gahn to compel the prosecution to file criminal charges against her. Also, Monday morning, the judge denied a request from Assistant Cook County State's Attorney Shauna Balaker to exclude the testimony of a defense witness from the trial. The witness, Damon Pryor, is a former boyfriend of Van Allen and the father of her 5-year-old child. He was flown in last week as a last-minute witness, and his testimony could undermine some of Van Allen's testimony today. In open court this morning, defense attorney Sam Adams Sr. said he expects Pryor to testify that Van Allen told him R. Kelly was not the man in the sex video at the heart of the case. Pryor is also expected to say that Van Allen once stole R. Kelly's watch. Bulaker argued that Pryor's testimony would amount to hearsay, but the judge disagreed. Whether Mr. Pryor is credible, that is up to the jury to decide, Gahn said. And then on June 2nd, 2008, the story picks up and it says, the most anticipated witness in the R. Kelly trial has arrived in the courthouse. Lisa Van Allen, 27, and her fiance, Yul Brown, entered the building around 9 a.m. Van Allen, who is 4 months pregnant, sported a black dress and a small baby bump. It says it's unclear when she'll take the stand, but prosecutors typically have saved their splashy witnesses for the afternoon. So individuals 2, 3, and 4 in the superseding indictment that I just read is Yul Brown, Damon Pryor, and Lisa Van Allen. And the let me see if they talk about Yul Brown more, because I thought he got arrested. He was arrested somewhere along the way. Let's see, she talked about being in jail for a month with a fight with another woman when she was 19. She also acknowledged she spent 2 days in jail for a domestic battery charge in 2006 after finding her boyfriend with another woman. Kelly's attorneys are expected to accuse her of offering to switch her testimony for a price. Let's see. I talked about that. And then also in this article, it says she tells of 3 sexual encounters, and then they're talking about 3 or 4 videos in the superseding indictment. So perhaps it's just the same testimony that she done already gave from the 2008 trial. Let me see. Okay, here's an article from January 7th, 2019. Yul Brown did an interview with CBS 46, and it says, Lisa is my son's mother. We met in 2007, right before the R. Kelly trial. Yul Brown was right by Lisa Allen's side at the trial. Why were you subpoenaed? The reporter asked him, and he says, because I had a lot to do with it. I had a lot to do with the whole situation. They asked him in what capacity. And he says, well, like I said, I really don't want to go into the capacity of it because I don't care if people think I sold it or she sold it. Brown is talking about one of the many tapes R. Kelly is alleged to have made with underage girls. Quote, he would never ask me if it was okay to be filmed, but he never hid the camera or anything like that, Van Allen said on Surviving R. Kelly in Lifetime. In the docu-series, Van Allen said R. Kelly recorded her and another girl. Okay, and then Yul Brown says it wasn't her in regards to the money because she said he ain't going to pay nothing because he never paid her nothing. I'm not saying I did it, but when I saw the tape, he was going to pay her something. Brown said footage of Van Allen never went public. You know, never saw the tape. You never saw the tape, Brown said. I made sure of that. I'm not going to say I made sure of it, but you didn't see the tape that she was on. He got that tape. So he's kind of like admitting that he tried to extort the man for the tape. So guys, that's it for me. This is going on long enough. Let me know what you think about this superseding indictment. Leave your comments below, rate the video, and subscribe to the channel if you haven't done so already. And until the next time, I shall talk to you guys later. Bye-bye.